Welcome to the National Crime Victim Law Institute's Quicktool on Privacy, PostConviction. The goal of this Quicktool is to provide both practitioners and survivors with an overview of issues that might impact a victim's right to privacy in the post-conviction context. Crime victims and survivors often care deeply about their privacy. The basis for victims' right to privacy can be found in the federal Constitution, in state constitutions, in statutory victims' rights acts, rape shield protections, privileges that protect the privacy of communications with certain professionals, including counselors, doctors, attorneys, and others. Rights to privacy can be found in other areas of the law as well. While all of us have a right to privacy, risks to that privacy arise in unique ways for victims of crime. Survivors often wish to exercise control over who has access to aspects of their life that they choose to keep private.
During the investigation of the crime and during the trial, my private information was being asked for and being asked about a lot. I had to describe what happened to me, and that could be really hard sometimes. But I also remember subpoenas asking for my private records too. Sometimes it felt like I was the one on trial and whose life was being investigated when I didn't do anything wrong.
This can be a really common feeling. During the pretrial and trial phases of a criminal case, protecting victims' right to privacy might mean opposing attempts by the prosecutor or by the defendant to gain access to a survivor's diary, Facebook, or mental health records. Or it might mean asking to have the victim be identified by a pseudonym, such as Jane Doe, John Doe, or Doe number 1 in court documents instead of using their full name. Or it could be making sure the victim's address or other personal information is not disclosed and is redacted from court documents. Those are just a few examples.
Once the trial finished and the defendant was found guilty of at least some of the charges, I figured I wouldn't need to worry about my privacy anymore. Are you saying that a guilty verdict isn't the end?
Each case is different, but it is important to know that privacy is a right that lasts throughout the sentencing proceedings, parole or probation or post-prison supervision, and through appeals or other challenges to a defendant's conviction. For example, if you decide to give a victim impact statement at sentencing, you may wish to consider what level of protection might be applied to that statement and who might have access to that information, so that you can be comfortable with the information that you choose to share. There may be some information about yourself that you would not want to share widely, but you may also decide that you are comfortable sharing as much as you want in that context. The key is knowing who might have access to that information so you can make the choice that's right for you. Another example of when you might think about privacy post-conviction is if you have any financial costs that you want the defendant to pay in restitution. When you submit documentation about these expenses, you may want to think about the type of information that can be on receipts and whether you might want to redact your name, address, or other identifying information before you submit them.
That makes a lot of sense. You mentioned something about appeals or parole. Why might privacy be something I need to think about then?
There are many ways privacy can come up in post-conviction proceedings. For example, if the defendant challenges their conviction because the judge denied their attempt to access a survivor's private information, such as counseling records, the privacy of that information can once again be at issue in the case, and a victim or their attorney may need to participate to protect the right to privacy again. And if you choose to make a statement or otherwise participate in parole or other post-conviction release proceedings, you'll want to know about the protections that are available to you and who might have access to that information or statement, so you can decide what you feel comfortable sharing. Those are two fairly common scenarios where victims' right to privacy comes into play, but it can also arise in other situations. Take, for example, a case where a court of appeals writes an opinion ruling on a defendant's challenge to their conviction. Judges often include some facts about a case in legal opinions to provide context for the decision. But if those facts disclose private information about a victim's right to privacy might be implicated. And sometimes when a defendant wants to challenge their conviction, they may try to seek additional private victim-related information in that context to help them make their arguments.
This is a lot to think about. I'm really not sure where to start to get more information about this. Do you have any suggestions?
Victim advocates, who can be associated with either a community-based organization, such as a rape crisis center or a domestic violence organization, or with the criminal justice system, including advocates in law enforcement offices or in prosecutors' offices, are amazing resources. Some places in the country, including through the Oregon Department of Justice's Crime Victim and Survivor Services Division, offer advocates that specialize in the type of victims' rights issues that arise in the post-conviction context. Another valuable resource is a victims' rights attorney. Victims' rights attorneys can give you legal advice about your particular circumstances and take other steps, including filing motions in court, to help make sure the survivor's right to privacy is protected.
All of these privacy issues seem like a lot to manage, but I think I'm ready to get more information so I can put together a plan and prepare for what might happen next.
This concludes our quick tool on victims' right to privacy in the post-conviction context. Thank you for joining us, and we encourage practitioners and victims to discuss privacy-related concerns throughout the criminal justice process. Because this video focused on providing an introduction to privacy post-conviction, it did not cover all privacy-related topics. Visit NCVLI's website for additional resources, including a number of articles in our online victim law library that focus on privacy, additional toolkit and quick tool videos addressing a myriad of victims' rights-related topics, and sample privacy-related pleadings and other documents. Practitioners can also visit our website to request technical assistance with specific questions relating to privacy or other issues that impact victims of crime. And consider becoming a member of NAVRA, the National Alliance of Victims' Rights Attorneys and Advocates, for on-demand access to sample pleadings and case summaries of decisions on a variety of victims' rights topics from jurisdictions around the country. Thank you for joining us.